One of the questions we sometimes get from business owners goes something like this: do I leave my small business to my family in my will? Hi, I'm estate planning and probate attorney Joel Beck with Peach State Wills and Trust in Lawrenceville, Georgia, and I'll answer that question in today's short video. So the question of today is from small business owners who ask, do I transfer my small business to my family in my will, or is there a better way? Well, yes, you can generally transfer your ownership interest of a corporation or an LLC via your will if that is allowed in the company's governing documents. There's always a starting point to review those documents: the operating agreement, the bylaws, any type of members or shareholders agreement, including buy-sell agreements. We need to see what those say. But if there's not a prohibition on transferring your ownership interest via your will, you can do that, but that might not be the best way. And if you own all of the business, if you're 100% owner, having the ownership of the company go through the probate process may certainly be detrimental to the business. Wise business owners, I think, are going to work to ensure that if they're suddenly incapacitated or suddenly fall dead, that other people have actual legal authority to act for the business, and they don't have to wait for the probate court to appoint someone with oversight and operational authority, responsibility for the business and for its assets. You see, importantly, we need to make sure that we have people with written legal authority where they can manage the business if a need arises because of the owner's incapacity or death. We want to make sure that the business can keep on operating, that customers get served, that employees can get paid. We want to make sure that somebody can run payroll and sign contracts and sign checks and hire and fire and deal with the day-to-day management. And we need written plans in place for the company to do that. And we generally want to do this apart from having the company be bound up, tied up in the probate court process after someone passes away. So the ultimate answer is you can leave your business to your loved ones in your will unless that's prohibited by the company's governing documents, but that may not be the best idea, which then often brings up the follow-up question, well, what is the best idea? What's the best way to do it? And I got to give you a lawyerly answer. It depends. It depends on the facts and circumstances of your situation. How many people are involved in owning and operating the business? How many employees do you have? What does the business do? Do you have people that you can trust either in the company now or outside, but who can get involved if needed to keep things going and to have oversight responsibility? Answering those types of questions is then going to let us really determine what your options are. And of course, importantly, we need to understand, what are your goals? Do you really want to transfer the business to your family? Or do you really just want it to be sold and have those proceeds go to support your family? That may have an impact on what you do as well. Now, if you're a business owner here in Georgia and you've done no planning for the business, maybe this is a wake-up call. There might be some alarm bells going off in your head that, hey, I need to take care of these things, and it might be a good idea to pick up the phone and start a conversation with us. You can reach us at 678-344-5342. We can chat for a few minutes and see if it makes sense to talk in more detail. Or if you're just starting to research this and get some information on estate planning, then visit us online at peachstatewills.com. Click on free info at the top and then select estate planning resources, and you can get our guide to estate planning in Georgia sent to you for free, no strings attached. If we can be of help, don't hesitate to reach out. Thanks.